All right. We're coming together. So just to kind of bring together where we've been and where we're going, I think that last panel, and particularly the Q&A in that last panel, really brought us to the crux of the matter, which is, what is the role of government in all of this? Right? We can have a lot of questions about what makes sense to teach, what faculty should do, what the makeup of a faculty should be, what the atmosphere on a campus should be. But what we're really asking here is, what is the role of a government, of an executive power, and the administration that surrounds it in controlling all of those things? And that's very different from some of the questions that I think might have been starting to float around. Right? There are things you can't say as a matter of law, and there are things you don't feel comfortable saying, and those may be different. And something that's happening now that feels really different from what's happened in the pathway of time that's led up to now is the intervention of law in these questions of what you can and can't do as an institution of higher learning. And so we heard from William Traynor, we heard from Ruth Kolker about the very specific intervention of government and about how that intervention has caused what may be an overreaction, maybe a sort of threat response, and we've seen that on our own campus. We've seen that on a lot of campuses, that we're in an atmosphere of reactivity to the actions of an executive. And I think part of what's happening now is easy to make the observation that critique of this administration and of the political movement behind it is legally risky in a way that may not have been true in previous times. That there's a governmental force to these conversations that wasn't there, and that there's a Venn diagram that's connecting this with racialized and gendered and questions of disability matters. And that the driving force behind this is the executive branch. Here to expound upon that is Bryan Adamson, who has until recently been the Associate Dean for DEI at this institution. And I say until recently for two reasons. One, he was already planning to come back to the faculty before his title precipitously changed. But we live in a time where his title precipitously changed shortly before he rejoined the faculty as a regular professor. And he's thought a lot about these questions and about the role of government in how universities approach these dilemmas. He is a very distinguished professor, having returned to Case, his alma mater, after 18 years at University of Seattle School of Law, or Seattle University School of Law. We are very, very happy to have him back here as an august scholar and outstanding colleague. Take it away.
Thank you, Dean Rosenblatt. Thank you all for being here, and thank you to Law Review members and staff for putting together this program. It's very, of course, timely and challenging topic, because we are living in challenging times. I have a to move
The
to.
keyboard is on.
Here we go. So, as Professor Rosenblatt alluded to, I'd like to spend maybe 30 minutes discussing the constitutional legal parameters of what is happening now with regards to the executive orders, the Dear Colleague letters, and how they have impacted higher education, particularly over the last 8 months. So we know that around February 14th of this year, United States Department of Education published a Dear Colleague letter. And that letter explained the new administration's positions with respect to diversity, equity, and inclusion, or DE&I, on those principles and federal anti-discrimination law. Now, a few weeks after that letter was issued, there was an announcement made by the DOE that it would require states and school districts, as well as universities like ours, to affirmatively certify their compliance with the DOE's interpretation of Title VI of the Civil Rights Act, as well as Students for Fair Admissions versus Harvard, within 10 days of that letter. And the question became whether or not these executive orders and the Dear Colleague letter, whether or not those merely restated existing law, or if they created new law that was required to be complied with. So we have these executive orders. The executive order regarding ending illegal discrimination and restoring merit-based opportunity. Here are a few passages from it. Right? The gist of it is this order touches on higher education through multiple means. Right? The order directs the head of each federal agency to include in every grant award, quote, a term requiring such recipient to certify that it does not operate any programs promoting DE&I that violate any federal or any applicable federal anti-discrimination laws. And then later, as a way to encourage the private sector and institutions of higher education to end illegal DE&I discrimination and preferences, the order requires agency heads to submit a report containing recommendations for enforcing civil rights laws and taking other appropriate measures. Agency heads must also propose a strategic enforcement plan to deter DE&I programs or principles that constitute illegal discrimination or preferences, and it identifies up to 9 targets for examination. One of the second relevant executive orders that were signed by President Trump shortly after he was sworn into office is the executive order titled Ending Radical and Wasteful Government DE&I Programs and Preferences. Had a Freudian slip, I think, right? This order here directs the head of each federal agency, the Attorney General, and directors of the Office of Management and Budget to terminate, and it also applies to the Office of Personnel Management as well, to terminate to the maximum extent allowed by law all equity action plans, equity actions, initiatives, programs, equity-related grants or contracts, and all DE&I or DEIA performance requirements for employees, contractors, or grantees. This would include certain things like cultural competence training, et cetera, for employees or public-facing staff members or employees, for example. This executive order directed agencies to recommend actions to align agency or department grants with a policy of equal dignity and respect, or in DE&I's, this is a quote here, DE&I's infiltration of the federal government. And then the third relevant EO that was signed in January specifically addressed issues of anti-Semitism that had really come to a head after the October 7th attacks in Israel. And in response to that, the Department of Education officials and employees of the Office of Civil Rights were told that they would be expected to prioritize anti-Semitic actions or allegations of activity, anti-Semitic activity on campuses over other civil rights cases. So in February, you then have this Dear Colleague letter, right? This Dear Colleague letter, as I said, was issued on February 14th of 2025, right? And it further advises, once again, that 14 days thereafter, the Office of Civil Rights would take appropriate measures to assess and to ensure compliance with it, right? So that's the context of all of this, right? So two things up front, right? Executive orders are not law, right? Those do not have the force of law. An executive order is a written directive signed by the president that orders the government to take specific actions to ensure that the laws be faithfully executed. And that might mean, like it's done in this case, telling the Department of Education to implement a certain rule or declare a new policy priority. Executive orders, however, cannot override federal laws, nor are Dear Colleague letters, right? Dear Colleague letters signal or give advice or give notice about how the agency interprets existing law. And that is critically important in this context, how it interprets existing law, because that is the core debate that we're seeing in the courts that are challenging this Dear Colleague letter by various organizations and individuals as plaintiffs. So what the Trump administration has done is sort of leveraged by two approaches ways to ensure compliance, right? Through enforcement actions and certifications, I should say three, and termination directives, right? To ensure that these executive orders and by extension the Dear Colleague letters as enforced are complied with under the pain of termination of certain benefits, such as grants, for example, or worse, litigation and lawsuits by the federal government against institutions. So we saw in response, however, the responses of universities, for example, sort of took maybe three avenues, right? Someone would say, I would say, like ours, there was anticipatory compliance without awaiting any prompting directly from the administration. Our university scrubbed every reference to diversity from its websites, even at least initially, going so far as to if there were black faces. Some of our black alumni who were presented on our websites were gone. Right? They walked that back after they knew or realized how absurd some of the things that they were doing were, right? Others lay low, they just sit back in the cut and just watch everything go on around them, right? Other universities have done that, right? The others, like Harvard, fight, right? So those were the three tacks, right? And by my count, according to a website called Just Security, about 18 lawsuits have been filed against the Trump administration on the grounds of this DE&I, this Dear Colleague letter, and what's flowing from it. And so what I want to do with my remainder of my time is spend some time talking about what's happening and kind of my position or reasoning why I think that what they're doing is unconstitutional, as well as violative of the Administrative Procedure Act. Right? I come at this as a civil proceduralist. I know some about the Administrative Procedure Act just by virtue of my teaching mass media law and policy, where we have to engage and interface with these issues, or my students and I, quite often with regards to administrative rules and administrative compliance and the Federal Communications Commission, right? So, and then want to talk to you about prescriptions if we have time. I have several prescriptions, but we may not have time to go through them all one by one, but there are a few I just would want to highlight, all right? So, here we go. So, the APA, right? The Administrative Procedure Act, right? Basically under Section 704, Title 5 of the APA, that allows judicial review of, quote, any final agency action for which there's no adequate remedy in a court, end quote, right? So this tees up the very first legal question that we have to ask in this inquiry. So is what the DOE, DOJ, Office of Civil Rights, is what they're doing with this Dear Colleague letter of final agency action, right? An agency action that purports to impose legally binding obligations or prohibitions on regulated parties, and that would be the basis for an enforcement action for violations of those obligations, is tantamount to a legislative rule as well, right? To say it similarly, an agency action that sets forth legally binding requirements is a legislative rule. And so in answering the affirmative, implying the facts to that rule, it can be shown that the OCR and the DOJ is applying and implementing this Dear Colleague letter as if it is law, as if it is a legal rule that must be complied with. And we'll get into some details and some examples later, right? This letter is not just hortatory or tentative or interlocutory in nature. It commands, it requires, it orders, it dictates, it sets forth the agency position on these particular issues, right? And before certain actions occurred in court, the Department of Education itself was applying the letter as if it were binding, right? It referenced the letter as a basis, for example, of its investigation of 51 different colleges, right? It continued to use the letter as enforceable via the FAQs that are part of the updated Dear Colleague letter. It refers citizens to the DEI portal, where they can, anyone who feels that there's a violation, a real perceived violation of the Dear Colleague letter, can file complaints, lodge complaints, right, et cetera, et cetera, et cetera. Most importantly, though, the letter's directives are changes from prior law, and they sound binding. For example, so Title VI and the SFFA decision, Supreme Court, right, has never, ever been interpreted to preclude teaching about concepts related to race. They've never been interpreted like that, right? The administration, for example, in this case, they could have said, and was perhaps trying to say, right, some type of guidance that simply clarified its position or its thoughts or its intent, for example, to prioritize Title VI prosecutions in favor of majority people. It could have said that, right? Or that it was going to intend to apply to against discrimination against all groups, even those in the majority. It could have said all of that. But it went much farther than that by expanding the definitions of stereotyping by expanding, the definitions of stigmatizing by expanding the definition of discrimination to reach entirely new areas of conduct, right? And it did so in a way that seems legally binding, right? And as I said, just to reiterate, that it seems like a statute, it seems like a rule or a law or a legislative rule, because it seems to supplement a statute or adopt new positions that were not existing before, effectively, February 14th, right? Also, looking like a final rule or final act is the certification requirement. That's part of the Dear Colleague letter. Certification requirement requires, as I mentioned earlier, requires institutions such as ours to certify, to swear under pain of litigation and perjury that they have no initiatives, no programs, for example, that run afoul of this DCL directive, right? The problem there is that institutions have always had to submit certification requirements, always, right? And as a matter of fact, just less than a year before this February 14th letter, the institutions had done that, right? So why, a year later, are you now requiring them to do it again? Right? That's why this looks like a legal rule or a legislative rule and a final rule, because they are, once again, tethering enforcement and punitive consequences to completing that certification requirement that is now a part of the DCL. So that just sets the stage, right? So you have to, as an initial matter, a court can examine legal rules, final rules, right? Legislative rules that have the air or in operation are in fact behaving like final rules. Then you get to these requirements of what are you supposed to do? What is an agency supposed to do when it wants to implement a new rule? Right? What is it supposed to do? Well, first and foremost, they have to provide notice and comment, where they notify everybody in the world, we're about to revisit this rule, or we are thinking about implementing this new rule. Right? It goes into the congressional record, et cetera, et cetera, et cetera. Here, they put it in a footnote of the Dear Colleague letter. If you got any complaints, you got any issues, here's the email you can write your complaints to. Right? That's not the way you do it, right? That's not the way you give notice and offer or invite comment, right? There's also concern about their approach violating the Paperwork Reduction Act, right? By just what I was just referring to, by requiring, for example, these institutions such as ours to issue another certification again that we are in compliance with whatever the DCL says we need to comply with, right? The Paperwork Reduction Act is something that is administered or managed by the Office of Personnel Management, more specifically, the Office of Management and Budget. And it was passed in 1980 as a way of agencies to perform information gathering and data collection in a way that was more effective and efficient. And as the title said, to reduce paperwork and burdens that come along with having to provide documentation or information time and time again, right? And the PRA requires agencies seeking to collect information from regulated entities to conduct a formal, quote, an evaluation of the need for the collection of information, end quote, and consider the burdens of collecting that information. and that evaluation usually requires notice and comment. Right? Then you get into what is often the meat of the concerns and considerations about a new agency rule. Whether or not that agency rule is arbitrary or capricious, right? And the standard being an agency's decision, in this case, the decision to construct and articulate and threaten and in fact enforce the operative terms and language of the Dear Colleague letter, that decision is arbitrary and capricious if, quote, the agency has relied on factors which Congress has not intended it to consider, entirely failed to consider an important aspect of the problem, offered an explanation for its decision that runs counter to the evidence before the agency, or is so implausible that it could not be ascribed to a different view or a product of agency expertise. And that's West Virginia versus Thompson. The government's failure to recognize that that it went beyond merely restating settled principles of Title VI and other civil rights laws, right, is enough. But they did other acts. They insisted that the letter and certification don't require any type of particular process, no notice and comment process. But they have no administrative record of investigation with regards to this Dear Letter Colleague. It's failed to consider any countervailing factors as to whether or not what they're saying in this Dear Colleague letter is appropriate, makes sense, is good or not, right? Change of position is another concept or principle, rather, that a court will explore, examine as to an agency action. What was it? FCC versus Fox Television. This is one of my favorite cases out of mass media, and it has to do with the indecency and obscenity doctrine on broadcast television. And it says that an agency is required to, quote, display awareness that it is changing position, end quote, and, quote, show that there are good reasons, end quote, for its new policy. Now, failing to acknowledge or explain a change is evidence, it said, that the agency, or say the government rather, has entirely failed to consider an important aspect of the problem, end quote, right? Here, the government changed its position, as I said before, one way of looking at it, or say one way rather, by asserting that certain discussions of race constitute discriminatory practices and violate Title VI and the SFFA. Now, prior guidance didn't mention any of that, right? The prior guidance that the OCR had given mentioned none of that, right? And the government has attempted to sort of explain away that lack of consideration about their changed position by saying that, insisting that anti-discrimination laws protect majority groups as well. Well, yes, of course they do, right? But nobody disagrees with that, right? What's new here is the requirements, the rereading and reconstruction and reinterpretation of Title VI and SFFA, right? So they could have, for example, just simply said, yeah, we want to focus on reverse discrimination. But they went farther than that, right? Letter and certification also represent a significant change in position because a prior guidance was removed back in January or February 2025, that interpreted the SFFA, providing that, quote, nothing in the SFFA decision prohibits institutions from continuing to seek the admissions and graduation of diverse student bodies, including along those lines of race and ethnicity, through means that do not afford individual applicants a preference on the basis of race and admissions, end quote. That's what the SFFA decision said, and that is what they had, the DOE at that time had interpreted it to say, or say that was their interpretation. Well, that was removed, that prior guidance was removed without explanation, and then said that prior guidance, that would be ignored. All right. So that's another example of the lack of thought that went into this new or changed position with regards to prior factual findings and evidence. The agencies are bound to analyze relevant data and articulate satisfactory explanations for its actions, as well as rationally connecting it to the facts found and the choices made. That is, say, basing their new policy on evidence and on research. For example, in this case, by marshaling evidence, putting it into the record that there's been discrimination, systematic discrimination against white and Asian students, or that universities had embraced pervasive race-based preferences. It did none of that, right? With regards to existing state and federal standards, the Office of Civil Rights and Department of Justice seems to have sort of misinterpreted or misunderstood some of the baseline understandings of what they could do and could not do under Title VI and the SFFA. Right? The court or a court, in looking at agency actions or changes, can also look at reliance issues and reliance interests. That is to say that to the extent that organizations and entities such as schools relied on former interpretation and directives, but now have to change those, that those changes and the weight, the cost, the consequences of those changes should be and can be taken into account. Shuttering buildings, laying off workers wholesale who maybe did DE&I work or counseling or cultural competence training, right? Extinguishing programs. Those are all sort of factors or examples of ways in which institutions may have relied upon the former interpretation. Much? 2 minutes? Former interpretations to their detriment. And so that's another concern and consideration. Right? Constitutionality, right? We can make quick work of this.
We can go till quarter after. Like the schedule says quarter.
Oh, okay, all right. Thank you. All right, cool, thank you. All right. I don't want to be screedy. But yes, we can still make quick work of this. I do. Here are just some examples of language in the Dear Colleague letter that I recommend to you. And that I suggest that those are just examples of ways in which we can look at this Dear Colleague letter and its constitutionality from the perspective of the First Amendment and the Fifth Amendment particularly. So we have sort of three threads with regards to the First Amendment, with regards to content-based discrimination, viewpoint-based discrimination, and compelled speech. Just to remind you, and once again, this is sort of underscores something that Professor Rosenblatt just had reminded us, is that we're talking about government action. We're talking about the federal government and what it can and cannot do with regards to First Amendment. This is not concern private actors and what they do or don't do with regards to First Amendment rights and abridging them, for example. And we know that any of these types of discrimination based under the First Amendment will be reviewed for strict scrutiny, right? fatal in fact, as some of us are fond of saying or reminded of, right? So, First Amendment right prevents the government from prescribing speech, right? Even when expressive conduct because of disapproval of the ideas. You can't do that just because you don't like what someone is saying. Because the government has no power to restrict expression because of the views of its message or the subject matter's content. That was held most poignantly in Texas versus Johnson, the famous or infamous flag burning case in 1989, right? Reed versus Town of Gilbert, Arizona, billboards and zoning laws, rather. Such laws are presumptively unconstitutional and look into an inquiry as to whether or not determining the content neutrality is whether the government is adopting a regulation of speech because it's agreement or disagreement with the message it contains, right? First Amendment doesn't countenance content-based regulations, not only content-based regulations, but also viewpoints, right? In terms, especially in matters of public interest, political issues, for example. Legislation or executive actions regulating speech, depending on the identity of the speaker, are also subject to strict scrutiny because you are seen as a way or method to control the content. Let me just go back to this briefly, I think. So we see here, for example, in the second bullet point, proponents of these discriminatory practices have attempted to further justify them, ... right? That's what they say in Dear Colleague letter. That is an example of a viewpoint-based discrimination, where they are targeting those who convey a particular message. What this says is that someone who pronounces anti-DEI or espouses anti-DEI sentiments or expressions of behavior, perfectly fine. What you do is legal. We're not going to touch you, right? But if you are a proponent, we're coming after you, and this letter gives us the authority to do that. That's what's problematic with that constitutionally. Right? Flag, holding your hand over your heart when you standing when you salute the flag. The West Virginia versus Barnett case, right, is the seminal case in terms of compelled speech. You cannot be made to stand up and put your hand over your heart and recite the Pledge of Allegiance, for example, right? That is considered as compelled speech. More recently, 303 Creative versus Atlantis, and I think there's some rightful arguments about whether or not that the narrowness of that particular decision or not. Professor Hill may know something about this. I'm sure she does know a lot about this. But that said, right, unconstitutional conditions, right? The government may not deny benefit to a person on the basis that it infringes upon his constitutionally protected freedom of speech. Now, one of the things that I've seen in reading some of the cases, I've seen that argument sustained lesser degree than the others, right? The idea that the government is leveraging grant money by saying you got to do this over here. Right, we're going to take away your grant money here if you don't do this, right? And so the question becomes whether or not that is an unconstitutional condition. There are so many contours to that concept and principle that we can debate whether or not it belongs in here as an argument. Then you get into this fundamental issues and notions of vagueness, and I'm closing now. The idea of the Fifth Amendment due process clause abhors vague rules and actions and conduct. The fundamental notion underlying the due process clause is that people of ordinary intelligence should know when they're violating a rule or a law. And if that rule or law is so vague as to not give someone notice as to when they are stepping into it or onto it, then that is constitutionally problematic, right? And so you have here the various phrases and terms that are used in the Dear Colleague letter that just have no meaning, aren't defined, have no tether to them, and historically have never been a part of evaluating whether or not discriminatory actions have happened. Stigmatization. DE&I, what is DE&I, right? The letter doesn't define it, right? What is equity, right? Host of things that make this Dear Colleague letter vague, right? Unconstitutionally vague. And the risk is that you leave it to the decision makers, the government, to decide, okay, you're wrong. They're going to require you to take an act and then say you're wrong or you're right, right? And so that is what the Constitution abhors, right? There's also this, I'll call it offensive because it is, undercurrent that courses through this Dear Colleague letter, as well as what we've heard in public conversations over the last year, 2 years, about DEI hires, about, well, I don't want to fly a plane if a black person is a pilot. I don't want to be in that plane, right? This whole notion that somehow just because somebody is of a particular identity, that brings tragedy and danger. Right? And that the fact that this Dear Colleague letter says that explicitly is the other consideration that gives us pause. So in closing, I had recommended some ways in which universities and institutions can sort of fight back or push back on this Dear Colleague letter, as well as the new initiatives and this new regime that this government has implemented. And so I won't go through all of those. What I do want to say, though, is what we've seen on college campus. It's not just college campus. It's not just public or private. It's this erasure of identity notions, an idea that these places still can be welcoming to people of various and all identities, and under the sacrifice of this new approach. And what I think that has done is left those who are of those identities or who are allies of them feeling outside and literally looking for places and peoples and programs that will make them feel a part of things. I think that universities and institutions, and we'll probably hear about this afternoon, for example, that can tether a new mission that doesn't dissolve or dilute their commitments to diversity, equity, inclusion, and belonging. They can do that by tethering their work and their to their mission statements, to other things that they do, even if they can't call it diversity, right? That there are other things that they can do and that they should do and that they should signal that they are doing for those institutions. Because, right, anti-discrimination still applies to us, right? It still applies. It's still illegal to discriminate against women, against black folk, right? Against LGBTQ. It's still illegal, right? And that's what they need to be reminded of. We also need to be reminded of the value of diversity, equity, inclusion, and belonging. That it still holds value, despite what they might think, right? So that's my spiel. That's my thought and on this. I thank you again, and happy to have a conversation afterwards. All right. Bye bye.